Thank you, Sarah. I'd like to make clear that my remarks today are not just my own, but I'm speaking also for the two organizations Sarah mentioned, the Cuban American Alliance Education Fund and CASA US Cuba. On April 17th of this year, Congressman Dennis Kucinich sent a letter to Attorney General Alberto Gonzalez, urging the U.S. to send Luis Posada Carriles to Venezuela to stand trial for his crimes. Congressman Kucinich cited the bombing of a Cuban civilian airliner, the car bomb that killed Orlando Letelier and Ronnie Moffett here in Washington, the bombings at Cuban hotels that killed an Italian tourist and wounded 11 others, and the attempted bombing of an auditorium at Panama's National University. Congressman Kucinich quoted President Bush, who just a week earlier had said, "I vowed that if you harbored a terrorist, you're equally as guilty as a terrorist." That's a doctrine. In order for this country to be credible, when the president says something, he must mean it. I meant it. The day before the president reiterated his doctrine, Posada, who had been in U.S. custody, was set free to await trial on minor charges of lying to immigration officials. As we all know, this week, a federal district judge dismissed the indictment, and Posada is now wholly free unless and until the U.S. initiates further action. On May 3rd, 8 days ago, Congressman William Delahunt of Massachusetts sent a letter to Attorney General Gonzalez. Citing facts like those cited by Congressman Kucinich, Congressman Delahunt asserted that there was sufficient evidence to conclude that Posada had participated in terrorist activity, such as those contemplated under the Patriot Act, and asked for an explanation of the failure of Mr. Gonzalez to certify Posada as a terrorist under the law. He pointed out that records of the Department of Justice identified Posada as a terrorist, and that the FBI had described the matter as a danger to national security. On May 4th, Congressman Jose Serrano called in an interview for the trial and extradition of Posada. What provisions of law did the three congressmen have in mind? The government of Venezuela on June 15, 2005, almost 2 years ago, sent a petition to the U.S. government for the extradition of Posada on 73 counts of murder in the first degree. The petition was based on treaties to which the U.S. is a party. These are the Venezuela-U.S. Extradition Treaty of 1922, the Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation, in force since 1973, and the International Convention for the Suppression of Terrorist Bombings, in force since 1998, but retroactive where a treaty of extradition exists between the parties, as is the case here. The Convention for the Suppression of Unlawful Acts Against the Safety of Civil Aviation is very clear on what must be done. At Article 7, quote, "The contracting state in the territory of which the alleged offender is found shall, if it does not extradite him, be obliged, without exception whatsoever, and whether or not the offense was committed in its territory, to submit the case to competent authorities for the purpose of prosecution." The other convention for the suppression of terrorist bombings contains practically identical provisions. In its Article 8, there is no discretion. To repeat, under the treaty, the state in which the alleged offender is found, if it does not extradite him, shall, quote, "be obliged, without exception whatsoever, and whether or not the offense was committed in its territory, to submit the case to its competent authorities for the purpose of prosecution," unquote. In addition, it is well-settled law in the United States that the extradition process has priority over any immigration proceedings. The lead person within the administration in these matters is the same person who is charged with the implementation and execution of all laws governing the federal government, the Attorney General, Alberto Gonzalez. To this day, the U.S. has not answered the petition for extradition. It has taken no step to pursue criminal prosecution as required by binding treaties. It has done nothing except to file minor charges related to Posada's illegal entry to the country. And those charges were dismissed this week by the federal district court hearing the matter on procedural grounds. The judge in that action accused the federal prosecutors of engaging in, quote, "fraud, deceit, and trickery," unquote. Referring to the interview of Posada by immigration officials, she noted that, Quote, in addition to the irregularities inherent in the interview itself, the court finds the DOJ's involvement within the case suspicious, unquote. In the conclusion of her decision, the judge further ruled as follows. The realm of this case is not, as some have suggested, terrorism. It is immigration fraud. Terrorism and the determination of whether or not to classify an individual as terrorist lies within the sound discretion of the executive branch. It does not lie with this court. To what was the judge referring when she said that a decision on classification as a terrorist lies with the executive branch? Congressman Delahunt knew what the judge meant. In his letter, he cited U.S. Code Title 8, Section 1226A, A13, a section added to immigration law by the Patriot Act. Under those provisions, an alien is inadmissible who, among other things, 1, has engaged in terrorist activity, 2, a consular officer, the Attorney General, or the Secretary of Homeland Security knows or has reasonable ground to believe is engaged in or is likely to engage after entry in any terrorist activity, 3, has under circumstances indicating an intention to cause death or serious bodily harm incited terrorist activity. 4, is a representative of, among others, a political, social, or other group that endorses or espouses terrorist activity. Or, Section 7, Paragraph 7, endorses or espouses terrorist activity or persuades others to endorse or espouse terrorist activity and or support a terrorist organization. A terrorist activity is defined in part as any activity which is unlawful under the laws of the place where it is committed, or which, if it had been committed in the United States, would be unlawful under the laws of the United States or any state, and which involves any of the following. 1, the hijacking or sabotage of any conveyance, including an aircraft, vessel, or vehicle. 4, an assassination. Or 5, the use of any explosive, firearm, or other weapon or dangerous device other than for mere personal monetary gain, with intent to endanger directly or indirectly the safety of one or more individuals, or to cause substantial damage to property. A further subsection on foreign policy provides that, in general, an alien whose entry or proposed activities in the United States, the Secretary of State has reasonable grounds to believe would have potentially adverse serious foreign policy consequences for the United States is inadmissible. Now, what is the role of the Attorney General in certifying a person as a terrorist? The Attorney General is given authority to certify a person as a terrorist. Further, the Patriot Act provisions cited state at the very beginning the following. 1, custody. The Attorney General shall take into custody any alien who is certified under paragraph 3, i.e. as a terrorist. 2, release. Except for limitations in time of certain circumstances, the Attorney General shall maintain custody of such an alien until the alien is removed from the United States. Such custody shall be maintained irrespective of any relief from removal for which the alien may be eligible, or any relief from removal granted the alien, until the Attorney General determines that the alien is no longer an alien who may be certified. To summarize, under facts well known to the Department of Justice and under applicable laws, the U.S. government is required to take one or more actions in this case. Those are: pursuant to treaties, to extradite Posada to Venezuela, or to bring criminal action here against Posada. Pursuant to the Patriot Act, to certify Posada as a terrorist and bring action against him. The person at the center of making the relevant legal decisions and taking appropriate action is Attorney General Alberto Gonzalez, the highest legal officer of the nation. To date, Mr. Gonzalez has done nothing of what is required of him by virtue of his position and under international and domestic law. Mr. Gonzalez, we await your next step.